Lord, may it please you, I appear with my learned friend Mr. Cafferty for the Appellant Local Authority, and my learned friends Mr. Narby and Mr. Marcus appear for the Respondent Appellant. My Lord, in the present appeal, the Appellant Local Authority decided that the Respondent, Ms. Munemo, was intentionally homeless from her property at 87 Thompson Avenue, Wolverhampton. The manner in which they reached that conclusion and the legal principles applicable to that conclusion are the subject matter of this appeal. The initial decision was made on the 15th of September 2023, and it was confirmed on review on the 11th of July 2024. It's therefore in relation to the loss of that particular accommodation that the focus of the questions arising in this appeal relate. And what I thought might be helpful is if we summarise our case in 8 propositions. The first is that the elements of intentional homelessness fall to be judged as at the date Ms. Munemo ceased to occupy that accommodation, not the date on which she acquired the accommodation. And in the present case, she ceased to occupy pursuant to the warrant that was issued as a result of the possession order made by Deputy District Judge Sharp. Secondly, Ms. Munemo's current state of homelessness arose because she was evicted from her secure tenancy at 87 Thompson Avenue. Third, she was evicted because the county court made an outright possession order, which was enforced by warrant. Fourth, the court made an outright possession order because it was satisfied under the Housing Act 1985 that a ground for possession of the secure tenancy had been established, and it was reasonable to order outright possession. 5, the ground for possession on which possession was ordered was ground 5 of Schedule 2 to the Housing Act 1985, that Ms. Munemo had knowingly or recklessly made false statements which induced the local authority to grant her the tenancy. 6, if the court had not been satisfied that she had made those false statements, it would not have been able to make a possession order. Mere ineligibility for a grant of a tenancy is not a ground on which a secure tenancy can be brought to an end. 7, but for those false statements that the judge found to have been made, judged at the date she ceased to occupy the accommodation.
Sorry, could you start this one again?
Sorry. But for
Yep.
the false statements that the judge found to have been made, and looked at as at the date she ceased to occupy the accommodation, that accommodation would have remained available to her, because there was no other basis on which the authority could have or did claim possession. And 8, would it have been reasonable for her to continue to occupy that accommodation? We say, again, judged at the date she ceased to occupy, the answer to that is yes. She had a valid secure tenancy, and if she had not made false statements, there would have been no ground for possession available to the local authority on which it could have obtained her eviction. And hopefully, in the course
the date of ceasing to occupy the premises. there was no reason why it would not have been reasonable for her to continue to apply. Is that number 8?
That's number 8.
Except that there was a possession order.
Well, yes, but
So is it at the date?
it is at the date, but it is leaving out of account the deliberate conduct that led to the loss of the accommodation. And that's a proposition I'll hopefully make good in the course of my submission. So what we say is when assessing reasonableness to continue to occupy, you leave out of consideration the act that caused you to lose it, and then you look
That's Lady Justice Arden's.
Yes, exactly. Good. That's essentially the reason why we say the judge below was wrong, to focus on the question of whether at the time she was granted the tenancy she was eligible for it, and wrong to apply the reasoning of Lord Justice Lewison in the Chishimba case, which we say is a very different case. And the way in which I propose to structure our submission this morning is first of all to look at the elements of Section 191 of the Housing Act 1996, the provisions relating to intentional homelessness. Then look at the relevance of the security of tenure provisions of the 1985 Housing Act. And then, on the basis of those submissions, come to whether or not it was reasonable to continue to occupy at the relevant time. And finally, to distinguish the Chishimba decision, and if necessary, the decision on which Lord Justice Lewison relied in reaching his judgment in that case, the Exeter ex parte Glidden case, Justice Wood.
Should we just clarify for just one point to rest, which is that I think it's established that the respondent now in fact has other accommodation. Appeal is technically in that sense academic.
Well, I'm not sure whether the appeal is technically academic for this reason. The structure of the homelessness provisions of the Housing Act 1996 do not necessarily bring the duties owed to a person to an end simply because they have other accommodation. It might have that effect, but if that accommodation is temporary or precarious, the pre-existing state of homelessness might continue, and it might be argued that if the authority were wrong to find her intentionally homeless, they still owe her a duty. Now, the authority has not been informed of where the respondent has moved to, or on what basis she has moved. So I'm not prepared to concede at this stage that the appeal is academic.
No point seems to be taken around anyway.
No. And it is, we would say, a very important point of principle, the basis of which which was the basis for the grant of permission, in the sense that Lord Justice Newey, in granting permission, doubted whether or not Parliament would have intended the result appeared to be reached by the judge below, notwithstanding his doubts about whether or not Chishimba was distinguishable. We respectfully submit it is distinguishable, and I'll come to address you on that in due course if I may. So we say that even if technically it may be academic, there are very good reasons why this court should continue to support the appeal, and I'm not aware that anybody is asking the court not to. My Lord, could I then ask you to turn to the legislation in the authorities bundle, tab 2, begins at page 28 of that bundle. Sorry, tab 2 doesn't begin at page 28. I would like to begin at page 28. And I don't need to go to section 175 in any detail, but it's simply to note that this is the definition of homelessness and threatened homelessness for the purposes of the provisions of Part 7 of the 19 96 Act, and there are three categories of homelessness. One, where a person has no accommodation which he's entitled to occupy. I paraphrase, but for these purposes I don't think it matters. Two, accommodation that he can't secure entry to, or that's movable and he's got nowhere to put it in order to live in it. And three, a person is deemed not to have accommodation unless it's accommodation it would be reasonable for him to continue to occupy. So we see that in terms of the definition of homelessness, reasonableness to continue to occupy is also a concept that Parliament employed. But I don't think I need to take that point any further at this stage. We have also Section 176, which simply clarifies that accommodation is only available for a person's occupation if it's available for everyone who normally lives with him as a member of his family, or anyone who might reasonably be expected to do so. And by Section 177, in determining whether it's reasonable to continue to occupy accommodation, there are provisions related to domestic abuse, but I would simply direct the court's attention to subsection 2. Regard may be had to the general circumstances prevailing in relation to housing in the district of the local housing authority to whom he's applied for accommodation or for assistance in obtaining accommodation. And that will be relevant when we come to look at Glidden and the basis on which Mr. Justice Wolf made his decision in that case.
Sorry, what were you looking at then?
Section 177, subsection 2. The authority's right to take into account its general housing circumstances. My Lord, if I can then turn to Section 184 on page 33. You'll see that once an application has been made, if the authority by subsection 1 have reason to believe that an applicant may be homeless or threatened with homelessness, they shall make such inquiries as are necessary to satisfy themselves whether he's eligible for assistance and whether any duty, and if so what duty, is over him. We'll see when we come to the case law that there is some reference made to the date of the inquiry, and it's these statutory inquiries in my submission that the court's referring to. Section 185 on page 35 is a general provision excluding persons from abroad for a housing assistance under Part 7 if they are ineligible. And the scheme of the Act essentially, and I don't think there's any dispute about this, is that anyone requiring permission to enter is ineligible unless re-included into eligibility by regulations made by the Secretary of State. I only mention this because in Chishimba's case, Mr. Chishimba was ineligible for assistance as a result of Section 185. Mr. Munemo is not ineligible. So with that brief introduction to the legislation, can I then go to Section 191 on page 46 and to subsection 1 of that section. The person becomes homeless intentionally if he deliberately does or fails to do anything in consequence of which he ceases to occupy accommodation which is available for his occupation and which it would have been reasonable for him to continue to occupy. There are then some exceptions to that in subsection 1A, which I don't need to go to. Just to note subsection 2, an act or omission in good faith is not to be treated as deliberate. But it's not suggested that that's relevant here either. But coming back to subsection 1, it's my submission that as a starting point, it is clear that it is the cessation of occupation of accommodation that falls to be considered by reference to whether or not anything deliberately done by the person had the consequence of that cessation of accommodation.
That's quite a sentence. Can you repeat that?
The focus of section 191 is the cessation of accommodation.
Yes.
A cessation of occupation.
Yes. And it falls to be considered by reference.
It falls to be considered in relation to whether or not that cessation of occupation was caused by anything done deliberately by the person concerned. So, losing accommodation, leaving accommodation, is the focus of the inquiry of the local authority. And we say that that is supported by the Supreme Court decision in Highly, which I will come on to, but it's also relatively obvious from what the Act provides. And therefore, the local authority is directed to look at what led to that accommodation no longer being occupied. When the occupier ceased to occupy it, was it available, and would it have been reasonable for him to continue to occupy? The duties owed to a person who is intentionally homeless are at section 190. I don't think we need to go to them, but they're on page 44 if the court would like to see them. And the general principle is that they must, under subsection 2, provide a short period of accommodation to give the person a reasonable opportunity to find their own, and they must provide advice and assistance. Finally, under this piece of legislation, section 193 on page 48. This section applies where the local authority are satisfied that the applicant is homeless and eligible, and are not satisfied that the applicant became homeless intentionally. Also satisfied that he has a priority need. The relevance here, as we'll see when we come to the Highly case, is that it links the current state of homelessness to the reason for the loss of the accommodation deliberately. And as Lord Reid says, there has to be a causal connection between the loss of accommodation deliberately and the current state of homelessness. In the present case, I'm not sure that that is one of the key issues, but as a matter of structure of the Act, as the example we gave is if I lost accommodation as a student because I had a rowdy party, that could be said to be deliberate act in consequence of which I ceased to occupy accommodation, but unless that accommodation loss caused my current state of homelessness, it's irrelevant. So there has to be a link between the accommodation chosen by the authority as the accommodation lost deliberately and the period of homelessness currently faced by the applicant who applies as a homeless person. We say here, there's no doubt that it was the loss of accommodation at 87 Thompson Avenue that caused the applicant's current state of homelessness when she applied. And indeed, no appeal was pursued on any contrary basis. So, The starting point then, we submit, is that the Act mandates the consideration of intentional homelessness in relation to the loss of accommodation. And respectfully, we submit that the Supreme Court in a Hiley case, although that concerned on its facts somewhat different issues about intervening events which happened between the loss of the accommodation and the decision of the authority, which plainly doesn't arise in this case. The analysis of the Supreme Court, we respectfully submit, is instructive in this case, and that authority is to be found at tab 23. And we see on page 329, which is the first page, that the decision at letter H.
Sorry, could you just give us the page number on the authority?
It's page 329 of the bundle.
Thank you. Thank you.
The correct test was for the court to ask first whether the person deliberately had done or failed to do anything in consequence of which he seeks to occupy accommodation, which it would be reasonable for him to occupy, and if so, whether his current homelessness had been caused by that intentional conduct. And there had to be, open page, a continuing causal connection between that deliberate act and the homelessness existing at the date of the inquiry. And such causal nexus could be broken by an actual as opposed to a hypothetical intervening event. I don't want to go too far into that, but if I can pick it up at paragraph 3 of Lord Reed's judgment on page 334 of the bundle, there's a very brief summary of what the case was about, which I think it might be helpful for the court to have in mind. Where he says the issue raised in the appeal is in substance whether the review officer was entitled to be satisfied that the appellant became homeless intentionally on the basis that she deliberately gave up the accommodation in the hostel, given that she would have been homeless in any event by the time her application was considered. In that regard, it's contended that the birth of the baby broke the chain of causation between the appellant's leaving the hospital and her state of homelessness when the application was considered. So what had happened in that case was that the appellant was pregnant and living in a hospital. The terms of her occupation in that hospital were such that she couldn't live there with the child. So once the baby was born, which happened before she presented as homeless, she would have been homeless in any event. And the effect of that intervening act was what the court was considering. But in reaching its conclusion, Lord Reed went into some detail about how the act operates. And whether the earlier case of Dinn and Wandsworth Council, which was a House of Lords authority dating back to 1983, was still good law. And at paragraph 9 of his judgment, he says, page 336, to summarise matters I shall later discuss in greater detail, the case of Dinn concerns the definition of becoming homeless intentionally in what was then section 17.1 of the 1977 Act. That definition required the authority to consider whether an applicant had ceased to occupy accommodation which was available for his occupation, and which it would have been reasonable for him to continue to occupy, in consequence of his own deliberate act or failure to act. The House of Lords decided by a majority that the questions whether accommodation was available and whether it would have been reasonable to continue to occupy it were to be considered as at the time when the applicant ceased to occupy it. It followed that if the definition was satisfied at that time, it was irrelevant to that question to consider whether, if the applicant had not ceased to occupy the accommodation, it would have ceased to be available for his occupation at the time of the authority's inquiry. You can say at once that in relation to those matters, the decision appears to me to have been correct and to remain good law. Although he goes on to explain that that doesn't resolve the issue in the present case, it is important, in my submission, as a building block for our submission, that the relevant time to consider reasonableness to continue to occupy and availability is the time at which the accommodation ceased. And he says, then.
So in our case, that's the moment when the possession order is executed on the 21st of March.
Yes. Yes. And I will come on to the proposition that when considering reasonableness, you leave out of account the deliberate conduct that led to the possession. But that aside, yes, that is the time at which you assess those points.
Can I just wave a flag now?
Yes.
Because one of the things that's troubling me
My
in this case and my lack of understanding is that Section 191 has got to have the same meaning across a whole spectrum of behaviour. So at one end there's a person who technically moves out because they want to shack up with someone in another place, right through to our end of the spectrum, which is where Mr. Munemo's right to occupy doesn't cease until the execution of the warrant. Whatever meaning we give to the two conditions about the property or the accommodation, it seems to me has got to cater for all those cases.
Well, my lord, what I would say in response to that is this. First of all, it's not our position that it's necessary for the court in this case to make new decisions about the meaning of those sections. Our case is that on the meanings of those sections as they have been enunciated by the Supreme Court and by this court in other cases, the issue is how should the authority have applied the law. The only issue on which this court needs to decide essentially afresh is whether or not Lord Justice Lewison's decision in Shimba is applicable to these circumstances.
In particular, secure tenants.
In particular, secure tenants. The second answer I would give is this, that in relation to questions of causation, which is essentially what this case entails, and what Hiley and most of the other authorities that I will take you to, it's essentially a question of fact on the facts of the particular case. So a person who leaves accommodation because she wishes to go and live with a partner is not having different principles applied, but the application of those principles must necessarily depend on what she did and what the consequence of that was, which are essentially questions of fact for those cases. So there's never going to be an entirely common set of rules, if I can put it that way.
In this case, is the dispute between you who say the effective cause was the ability to, was the misrepresentation which gave rise to the ground 5 plan. The other side who say emphasise every possible opportunity that she was never eligible in the first place.
Yeah, essentially, yes. We say, if you look at the point, if you look at the issues rather, at the point of time that the Supreme Court in Hiley has told us we have to look at it, namely when you leave the accommodation, and you look at it on the facts, leaving aside what we say, if you look at it on that basis, the deliberate conduct of lying was the only thing that gave rise to a ground for possession, and was the only basis on which she could have been evicted. And that for the purposes of reasonableness to continue to occupy, applying Denton, you take out of consideration the deliberate act that caused the loss of the accommodation, and you say if that hadn't happened, or rather focusing on the situation without that, could she have stayed? And we say yes, because she had a secure tenancy, and ground 5 was the only basis on which it could have been terminated, therefore, absent those lies, it couldn't have been terminated. The respondents say, no, applying to Shimba, if she would not have been given the tenancy to start with, then it couldn't have been reasonable for her to continue to occupy it because she would never have had it.
Section 191 is premised on the fact that the person is in the accommodation
My
already.
lord, yes.
It's only, surely it's, am I wrong about this? It's,
No.
it's only concerned with the circumstances in which the accommodation is vacated and lost.
That's our argument, yes, my lord, absolutely. And that one has to look at it on the facts as they exist at that time, not on hypothetical facts as they may or may not have existed had something else not happened. At the time she was evicted, she had a secure tenancy of the accommodation. It was on the basis of secure tenancy that the local authority sought possession, relying on a ground and satisfying the court as to reasonable. That was the only way they could have got her out at that time. And that's what we say is the key factor in this case. And what we say is the key distinction between this case and in Chishimba. In Chishimba, at the time she was evicted, she still had no right to be in the accommodation because she was still excluded from assistance by the legislation because she had no right, she was an overstayer and therefore had no right to be in the country and therefore had no right to assistance under this legislation. So when the local authority found out that she was lying or had lied about her passport, strip away those lies, you had a person with no eligibility to be in the accommodation who was still in it, hence it was taken away from her. And it was the underlying ineligibility that caused them to take it away from her. Here, underlying ineligibility doesn't give rise to any basis for seeking possession against a secure tenant. And that is a deliberate choice that Parliament made.
I wonder if is there any scope for argument in relation to the tense that is used in section 191? And as you say, you're judging this from the point of view of somebody who is in occupation, and the question is, the person who becomes homeless intentionally, if he deliberately does, not did something. So if somebody has lied to obtain the accommodation, they deliberately did something. Well, that was before they were in occupation. Can we really say that if somebody lied to obtain the occupation, they do something which loses it?
Well, again, can I answer that in two ways? First of all, I think if we go to the case law, and if I take you to Lord Reed in more detail, the answer to that may become clearer, because it's accepted that the tense of section 191 is not an entirely clear way of expressing the concept. But secondly, if the consequence of what I have done is that I lose accommodation, then in our submission, that's enough. It doesn't matter when I did it, and we'll see from cases. In a sense, that's what Mr. Justice Sheeman was saying in the P and Hammersmith and Fulham case, which was commented on by Lady Justice Ardmisham, was intended. The act that you do and the consequence of that act in terms of losing accommodation do not have to be contemporaneous. And if they're not contemporaneous, you have to look back and see, well, if you hadn't done it, would you have lost the accommodation? I paraphrase probably horrendously, but that's essentially the position as we understand it. My lord, can I go back to Hiley? and pick it up at paragraph 22 on page 340. It's a fairly long passage, and my submission it repays consideration. I'm in my Lord's hands. If I don't want to read it all out, if it would be more convenient.
22 to when?
22 to 30.
Well, that we probably ought to read to ourselves then.
Yes. I'm grateful for your Lordship taking time to read that passage. My Lord, in relation to the question that your Lordship asked me a moment ago, Lord Reed refers to the case of Dyson and Kerrier in which Lord Justice Brightman, as he then was, replaces the present tense with the words has done or failed to do anything in consequence of which he has ceased to occupy accommodation which was available to his occupation in paragraph 26 of Lord Reed. We actually have Dyson case in the authorities bundle at tab 5, and immediately above the passage that is cited by Lord Reed, it's tab 5, page 96. It might be worth just noting the words of Lord Justice Brightman just by the second hole punched in the page, where he says, although subsections 1 and 2 of section 17 are drafted in the present and future tenses, they are in fact also referring to past events. Then he sets out the section, and then we get the passage quoted by Lord Reed.
Thank you.
So in my respectful submission, the tense doesn't detract from the proposition that if in the past, and applying Lord Reed's analysis in those paragraphs, if in the past you have done something that caused you to cease to occupy accommodation, the relevant question in that sense is, did that conduct which caused you to lose that accommodation have a causal connection to your current period of homelessness? And so at paragraph 59, and this is the last section of this judgment that I need to ask your lordships to look at, Lord Reed sets out his conclusion, as I've explained, didn't concern a relatively narrow issue. So we're back in tab 23, I do apologise. The House of Lords' decision that the elements of that definition were to be, whether a person, namely the interpretation of the definition of becoming homeless intentionally in section 71, the House of Lords' decision that the elements of that definition were to be considered as at the time when the applicant ceased to occupy accommodation, meeting the requirements of the definition, appears to me to have been correct. The decision as to the tempus inspiciendum remains good law in relation to the corresponding definition in section 1911 of the 1996 Act. It also remains true that if the definition is satisfied as at that point in time, it's immaterial under section 1911 to consider subsequent hypothetical events. I don't need the rest of that paragraph, which relates to definition of homelessness as it has evolved since Wolverhampton. But then at 60, he concludes that there must still be a continuing causal connection. And really to make a point that I've already taken my lords to. So what we say is that, and I've said, I think, in answer to questions from my Lord Justice Stuart Smith and my Lord Justice Phillips, but our point is you have to look at it as at that date, and you have to look at it on the facts as they exist at that date. The question then arises, is there anything, and it arises also from my Lord Justice Phillips' question, is there anything about the scheme of Part 7 that means that conduct that occurred before a tenancy was granted is excluded from consideration when considering how that tenancy came to be lost? We respectfully submit that there's nothing in section 1911 that limits the scope of the local authority's decision to actions that took place after the grant of the tenancy, if on the facts it could be seen that actions that were deliberate prior to the grant of the tenancy did, as a matter of fact, cause the loss of the accommodation. And an example which might be worth looking at very briefly is at tab 17 of the bundle, the case of Watchman in Ipswich Borough Council. and I can take a lot of it from the head note on the facts from H7 to H12. Essentially, the appellant and her husband were tenants. They were secure tenants who often got into rent arrears, and they subsequently exercised the right to buy with the aid of a mortgage. But the mortgage repayments were significantly higher than the rent. Then the husband lost his job, found another job at a lower salary. They got into mortgage arrears, and the mortgagee issued possession proceedings, and a possession order was granted. When they applied as homeless, H9, the authority found them intentionally homeless, because in entering into the mortgage, they knew they wouldn't be able to afford the monthly repayment. The decision was upheld on review, and the appellant appealed to the county court, and the court said, where the H14 I'm at now, holding 1, the authority must make a careful judgment on the particular facts to decide whether the homelessness is a likely consequence of a deliberate act on the part of the applicant, bearing in mind that it's the applicant's responsibility for the homelessness that is in question. Although required to consider circumstances at the date on which the applicant became homeless, they're entitled to have regard to events prior to that date. And if I can just pick it up at paragraph 8 of Lord Justice Law's judgment, where he sets out in a bit more detail what the decision was that the local authority had made. It's the very bottom of that page. Again, the reviewing officers, this time Mr. Howard, went into the facts in some detail, and he said this after describing various materials in the case. And he sets out 7 factors that meant that the obtaining of the mortgage was a deliberate act, described as a deliberate omission in failing to properly consider the implications of the mortgage. It was obvious that they'd been struggling to pay the rent for years. The schedule of expenditure they prepared to obtain the mortgage was clearly unrealistic based on their continued inability to pay their rent, and they must have known it was unrealistic. They didn't even follow their own opinion that they could afford $350 a month and instead agreed to take out a mortgage they knew was going to cost them at least $404 a month. They knew that they had other considerable debts. A fairly limited consideration of the mortgage offer would have revealed that the interest rate was variable. They admitted being told the interest rate would go up a bit, but failed to ask when or how much, and then they borrowed £6,000 more than they needed to, where even on their own calculations they knew they would be financially stretched. And then at 9, he says, did the loss of the job break the chain of causation and amount to an independent, new and separate reason for the homelessness? And he says there are some factors that support that, but over the page, at the top of page 258, the factors which support a finding that the unemployment did not break the chain of causation are essentially the matters that I've taken your lordship to: the previous financial history, lengthy inability to pay debts on time, other commitments, analysis of financial circumstances at the time the loan was taken out, reveal a family who clearly drastically overstretched themselves, strong likelihood the mortgage payments would increase significantly to a point where they would become unaffordable, etc., etc. And at paragraph 16, Lord Justice Law says there's no reason in any way to cavil at the conclusion that at the time of the homelessness occurring, it's the focus. Sorry, that the time of the homelessness occurring is the focus for the purpose of Section 191. But there's nothing in DIN as I see it to suggest that anterior events may not be relevant, nor that an event of homelessness may not have multiple causes. There's nothing to show that Mr. House shut his mind to what happened at the time when the applicant became homeless. On the contrary, it's clear that he had regard to the whole picture. Did he make a mistake when addressing the question of the breaking causation? And he concludes at paragraph 23 that Mr. Howard hasn't asked himself the wrong question. He has taken into account the antecedent history in deciding whether the applicant was made homeless at the time she was made homeless by virtue of her own act. And so
that's binding,
yeah,
because it's ratio of the court of appeal's decision. So you submit this binding authority that if we need it, the deliberate act can be before the person goes into occupation.
Yeah.
That's why you take us to.
Yes.
Sorry to be so slow.
This wasn't an act before occupation.
It wasn't an act before occupation, it was an act before the purchase of the property.
Why would that? That's not the question.
Well, but the loss of occupation was as a result of the mortgage company following purchase taking possession of the and obtaining a possession once. So it was before the applicants became the owners of the home.
What if somebody buys a property taking out a mortgage, which is on analysis was too much, and so they lose the property? That would be the same analysis. They're intentionally homeless because they bought a property that was beyond them.
Well, yes.
Or they might rely on it. What about Section 1913? Acts done in good faith.
1912, yes. Well, they might, and good faith is obviously going to be an issue in some cases where they say, well, I didn't know. So if a person buys a property and moves into it from a different property, and in doing so acquires a mortgage on terms that are wholly unrealistic, it's our case that the situation is exactly the same as it would be in the Watchman case. There's no difference in principle deriving from the fact that in Watchman they were previously tenants of the same property. Because the right of occupation that they lost was their right as a freehold owner, not as a secure tenant. So once they purchased the property, their possession was as freehold owners, holders of the freehold title. That was taken away from them when the court made a possession. It can't make a difference, we submit, whether the person had lived there prior to buying it or whether they lived somewhere else prior to buying it.
You haven't taken us to the passage which continues on page 504 of Watchman, paragraph 17 onwards, but does the essence of what then follows around causation come to this, that paragraph 22, that you look at whether homelessness is shown to have been a likely consequence of the applicant's deliberate act, bearing in mind that it's the applicant's own responsibility for his homelessness that the statute is looking for?
Yes, I dealt with that from the head note, I think.
Yeah, okay.
But rather than, I mean, there's also paragraph 20, I suppose.
Yeah, well, I mean, the passages immediately before that feed into that
Yes.
proposition, don't they?
Yes, and it's instructive in my respectful submission that where there are potentially multiple causes, you are focusing on any causes for which the person themselves was responsible. I don't resile from that. In fact, I probably rely on it. Whether or not the person, as in this case, managed successfully by means of their deliberate conduct to obtain a tenancy that they weren't entitled to, the fact is that they did so. And that was, we say, deliberate conduct. It was the deliberate conduct which gave rise to the ground for possession. It may also be helpful to turn briefly to actually Tshimba itself, not for the decision, but for part of the analysis of tab 21, where Lord Justice Lewison, at paragraph 7 and 8, on page 311, refers to watchmen in the middle of paragraph 7, having said that it doesn't need to be shown the applicant deliberately did something for the purpose of getting himself turned out. It's enough that he did something which had that consequence. Where there are potential multiple causes, the decision maker must carefully evaluate the fact in order to see whether the applicant's home is shown to have been the likely consequence. Sometimes this has been described as the effective cause. The ultimate question is, what is the real or effective cause of the homelessness? That question should be answered in a practical, common sense way. It is more than a but-for test. The effective cause will often be chronologically proximate, but it need not be. If there's more than one operative or effective cause, it suffices that only one of them is the deliberate act or omission of the applicant.
Is there any difference between talking about the likely consequence and the foreseeable consequence? The phrase you've used in a slightly different context.
I don't think so, my lord, in the sense that these are all judicial explanations of how to approach a statutory scheme which doesn't use the words either of likelihood or foreseeable. It's whether or not person left in consequence of a deliberate act. The way that the courts have interpreted that is to look for the sometimes called the effective cause, sometimes called the effective cause, sometimes the real and effective cause. Either way, it appears from the authorities that what one is looking at is whether it was likely that the conduct had the consequence of the loss of the accommodation. I don't know of whether that's necessarily the same as foreseeable. In some ways, likely appears to be a different word than foreseeable. Not even a word, a different concept than foreseeability. But ultimately, it seems that the courts are looking at the same type of issue, namely, it doesn't have to be shown as night follows day. That where there are multiple causes, one of them absolutely has to have been the accommodation, the conduct. It's enough that it was likely. But I'm not sure in this case that concepts of likelihood actually take matters very much further, because it's not disputed that she made the false statements. I appreciate it's not admitted that they were false statements, but for the purposes of this appeal, it's not disputed that she made the false statements. And it's not disputed that the judge found that her having done so gave rise to proof of ground 5 and reasonableness to evict. So, in many ways, the issues are not whether the conduct was such that it was so far removed from possession that it can't be said to have been foreseeable or likely. The issue is it the correct legal analysis that because possession was granted on ground 5 for the purposes of intentional homelessness, that was a deliberate act that caused the loss of the accommodation? Or, alternatively, is the correct analysis that of this court in Shishimba, where Lord Justice Lewison looked back to the start of the grant of a tenancy, or appears to have done, and we'll come on to that in due course, and say, well, if you lie, you should never have had it, and if you never have had it, you can't have continued to occupy. And that's really where, as my Lord Justice Stuart Smith, I think it was, at the start of my submission, identified where the parties have drawn their lines of battle. So, my Lord, that brings me to the second point, which hopefully I can take more quickly, which is what relevance does the fact that Ms. Munemo had security of tenure have to the issue that the local authority had to decide. It's common ground that Part 4 and Schedules 1 and 2 of the Housing Act 1985 prescribe the scheme for security of tenure that is relevant here. I don't know whether my Lords need me to take your Lordships to that statutory scheme.
Can you give us a reference?
Yes,
Tell us
tab,
where to go.
it's tab 1 of, I can go to it very quickly. Tab 1 of the bundle, page 4, is the beginning of Part 4 to the Housing Act 1985. And all I need to, I think, show my Lords is that by subsection 1, a tenancy under which a dwelling house is let as a separate dwelling is a secure tenancy at any time when the conditions described in sections 80 and 81 as the landlord condition and the tenant condition are satisfied. Section 80 on page 5 is the landlord condition. The landlord condition is the interest of the landlord belongs to one of the following authorities or bodies, the first of which is a local authority. Section 81, page 7, is the tenant condition, that the tenant is an individual and occupies the dwelling house as his only or principal home, or where the tenancy is a joint tenancy. Each of the joint tenants is an individual, and at least one of them occupies the dwelling house as his own or principal home. And then the meat of the provisions start at section 82 on page 8. The secure tenancy, which is either weekly or other periodic or a fixed term, cannot be brought to an end by the landlord except, as mentioned in subsection 1a, the tenancy may be brought to an end by the landlord, A, obtaining an order of the court for possession of the dwelling house and the execution of the order, and then subsection 2, the case in subsection A, paragraph A, the tenancy ends when the order is executed. And then at section 83, which provides for notices that have to be served prior to the bringing of possession proceedings, we see at subsection 1, the court shall not entertain proceedings unless the landlord served a notice or it's just an equitable to dispense with the requirements of a notice. We notice that subsection 2, a notice under this section shall be specify the ground on which the court will be asked to make the order and give particulars of that ground. And that then leads to section 84 on page 12, the court shall not make an order for possession of a dwelling house let under a secure tenancy, except on one or more of the grounds set out in Schedule 2. Or there's another scheme for mandatory possession orders called absolute grounds of possession, which don't apply here, nor do the flexible tenancy requirements referred to at the end of subsection 1. The court shall not make an order for possession, subsection 2, on the grounds set out in Part 1 of Schedule 2, grounds 1 to 8, unless it considers it too reasonable to make the order. So, the scheme is that the court can't make an order for possession under section 84(1) unless a ground is made out, and by subsection 2 it is reasonable to make the possession order. The court also, just to note section 85, the court by subsection 1 has power to adjourn proceedings for possession for periods such as it thinks fit, and subsection 2 to stay or suspend execution of the order or postpone the date for possession for such period or periods as the court thinks fit. So the court has an extremely broad discretion. And we see finally Schedule 1 is a long list of tenancies that are not secure. And paragraph 4, which you have at page 16, is a tenancy granted in pursuance of a function under Part 7 of the Housing Act is not secure unless the local authority has notified the tenant that it is to be regarded as secure. So Part 7 accommodation normally will not have security. Did not in Mr. Schindler's case. And then finally on page 17 we have ground 5, which you will see is in Part 1 and hence requires reasonableness as well as the ground to be made out. And the ground is very specific. The person or one of the persons to whom the tenancy was granted, the landlord was induced to grant the tenancy by a false statement made knowingly or recklessly by the tenant or a person acting at the tenant's instigation. And it is very specific in many ways. First of all, as we find out in the case of Islington and Uchak, that's not quite sure how to pronounce it, but in that case, the tenant at the time of the possession claim was an assignee of the original tenant, who was thought to have been implicated in the false statements that led to the grant of the tenancy. But this court held that ground 5 was quite clear. The tenant has to be a person to whom the tenancy was originally granted, and that Parliament had made the clear decision that assignees were to be protected from possession under ground 5. The second limitation is that it has to be shown that a false statement was made knowingly or recklessly and that it induced the grant of the tenancy. It is not enough that the applicant obtained the tenancy in circumstances in which they were not entitled to it. So ground 5 specifically puts the focus of attention solely on the question of a false statement. If I can turn to two cases, Uchak and Kazim. First of all, the Islington case of tab 16. And it was in this case that the local authority, Islington Council, faced with the fact that it may be unable to rely on ground 5 because the current tenant had not been the tenant granted tenancy, but was an assignee, raised as an alternative argument that fraudulent misrepresentation would be sufficient to allow them to rescind the tenancy outside the scheme of Part 4 of the 1985 Act. which was a proposition that this court rejected. Lord Justice Dyson, as he then was, giving the judgment of the cause, well no, giving the lead judgment, said at paragraph 27 on page 249 of the book, that the structure of sections 82 and 84 of the 1985 Act is clear. Section 82 provides what the landlord can do in order to obtain possession of a dwelling house which is let under a secure tenancy. He can only bring such a tenancy to an end by obtaining an order for possession. That means he cannot bring it to an end in any other way, for example, by obtaining an order for rescission. The only answer to this given by Mr. Arden is that an order for rescission does not bring a tenancy to an end, because such an order extinguishes it ab initio. In other words, once an order for rescission is made, it's as if the tenancy never existed. But the fact that it operates retrospectively does not mean that until the order was made, the contract does not exist. So, paragraph 28, the court will not likely conclude that Parliament has ousted common law and equitable rights, but such rights might be excluded expressly or by necessary implication. 29, in my judgment, the express wording of section 82, when read with section 84, is a negative enactment in Cook's sense, clearly showing Parliament intended to take away from landlords the right to bring secure tenancies to an end by rescission, whether of misrepresentation or any other ground. Schedule 2 provides a detailed and exhaustive code of the grounds on which a landlord may bring a secure tenancy to an end and obtain an order for possession. It's to be assumed that Parliament decided on policy grounds that a landlord should be able to bring a secure tenancy to an end and obtain an order for possession where it has been induced to grant a tenancy by fraudulent misrepresentation, but not where it has been so induced by an innocent or negligent misrepresentation. And again, 30, the code is exhaustive. That the code is exhaustive is clear from the express language of section 82. I would add it would have been most surprising if, having included fraudulent misrepresentation as a ground for possession, Parliament has intended that a landlord could claim possession for fraudulent misrepresentation by a different route, based on a different set of rules. I can think of no reason why Parliament would have intended to allow it. So it's a fairly strong statement by this court that if you've got a secure tenancy, there is only one way of terminating it, and that is to bring yourself within the Act.
It's common ground.
I believe it is, but the reason I mention it is because if one, coming back to my main point, that if one looks at the date of giving up possession, on the actual fact, you had a person with a secure tenancy who only got out through her lives, not through any underlying state of ineligibility existing earlier in the factual chronology. Likewise, in the Birmingham Kazim case at tab 20, this court, Lord Newberger, lost the role as he was at that time, held that merely because a council allocated accommodation to a person that they weren't entitled to does not mean that the tenancy is not valid and binding as a secure tenancy, which requires there to be a ground for possession. So in that case, this court, the second holding on page 294 of the bundle, the fact that in allocating the accommodation, the local authority took a procedural course that was unlawful in the sense of being susceptible to judicial review, didn't mean that any subsequent action by the body in actually granting the tenancy allowed the authority to void that grant on the basis that it was made ultra virus. So just below C. It was unlikely that Parliament intended that a failure to comply strictly with provisions in the 96 Act, which contained no reference to void, but should nevertheless render void any resultant tenancy. And since the selection of tenants in breach of the allocation scheme was made to a person to whom they had properly delegated the task of granting representations, the tenancies were effective. Uchak was considered when Lord Newberger observed that if a tenant obtained his tenancy by concealing his ineligibility, Ground 5 would normally provide the solution. So, whichever way you turn, the courts have been absolutely clear that if a person has a secure tenancy, there is only one way of terminating that tenancy, and that is in accordance with the provisions of the 85 Act. And we say respectfully that that casts a flood of light on the causation of the cessation of occupation of 87 Thompson Avenue in the present case. Given that the cessation of occupation resulted from the making and enforcement of the possession order, and the possession order could only have been and was only made on the basis of the false statement. And if the judge had come to the conclusion that no false statements had been made, that the tenants had come to acquire the property wrongly and had not been eligible for it, that would not have resulted in the loss of the accommodation. Loss of the accommodation was pinned exclusively to the making of the false statement. So, coming on to my third point then, was it reasonable to continue to occupy? And the relevant time for considering that being the date of the cessation of occupation, I'd like to come then to the Denton case at tab 18, page 262. And in this case, Mr. Denton lived with his mother in her home, and because of his antisocial behaviour, she asked him to leave. You see that from H9 on page 263. And he obtained a short-term accommodation living with his sister, but she eventually threw him out as well. And the local authority argued at H10 that he'd been evicted from his mother's home as a consequence of his behaviour. And he argued that it wasn't reasonable to expect someone of his age to always obey his mother. Therefore, his failure to do so couldn't lead to a finding of intentional homelessness, and the authority disagreed, and it relevant part of its decision is set out at 11. Reasonable to expect to abide by her house rules. Then the judge in the county court on appeal allowed the appeal on the basis that it was wrong to say that the behaviour had caused the loss of accommodation, because the authority ought to have considered whether he might have lost it anyway as a result of the deterioration in the relationship between him and his mother. At the fourth we're going to take Lady Justice Arden's judgment at paragraph 2 on page 265. She summarises her decision, and some of those paragraphs relate to the difference between a family home and a tenancy, which are not relevant here, but at 2(4), in determining whether it is reasonable for a person to continue to occupy his previous home, the court must disregard the deliberate conduct or course of conduct that led him to leave the home. And that is the principle that is established in more detail in the later parts of her judgment.
Where does it come from? Where does it come from? Because we've got the wording of the section,
I think the
which
start.
simply says
Sorry.
for the present purposes, assume I'm with you that the critical time is the moment of loss of accommodation. On what basis? What's the basis underlying the assertion that you ignore previous conduct?
I think
Isn't it simply a statement of, it's an unqualified statement of a requirement that the accommodation should still be available?
there were two statutory requirements. It should still be available, and it should be reasonable. It would have been reasonable for the applicant to have continued to occupy. The way in which Denton comes about, in my submission, is that if you don't leave out of account the behaviour which caused the loss of accommodation, then the requirement that it would have been available and reasonable to continue to occupy will never be satisfied. Because if I lose my accommodation, because the court makes a possession order, let's forget about lies, let's say I don't pay the rent. If I don't pay the rent and the court makes a possession order, then it's not available. And it can't be reasonable for me to continue to occupy accommodation with the bailiff knocking at the door.
Okay, so that's not,
So that's
not the answer. I mean that's
that's a practical basis, but in terms of the case law, I think probably the starting point is the Hammersmith and Fulham and P case, which is actually referred to in Lady Justice Arden's case, where the circumstances were such that petty criminals in Northern Ireland had annoyed their neighbours to such an extent that they had complained about them to the IRA. And the IRA had said to them, unless you leave Northern Ireland within 72 hours, you'll be killed. So they came to London. Hammersmith and Fulham said, you're intentionally homeless because you were criminals, and your conduct, at least in part, caused your need to leave the accommodation. It was argued on their behalf in judicial review proceedings that at the time they left the accommodation, plainly it wasn't reasonable for them to continue to occupy because they were subject to a death threat. And Mr. Justice Sheeman said, well, the behaviour which causes the loss of the accommodation doesn't necessarily have to be contemporaneous with the loss of the accommodation. You have to look back and say, if they hadn't done the act, would they have lost the accommodation? The passage in paragraph 24 of Lady Justice Arden essentially summarises what he says about that. He says, Mr. Arden submitted there was no material on which the authority could conclude that the applicants could reasonably have remained in their previous accommodation.
Sorry, I haven't got where we're.
I'm sorry, my lord, tab 18. It's Denton and Southwark.
Oh, we're back in Denton, I see. Sorry.
Yes, I'm just quoting P from Denton.
Can you just give us the page reference?
Page
Sorry.
273,
Thank
paragraph 24 of Lady Justice Arden.
Thank you.
And she says at paragraph 24, Mr. Arden submitted there was no material on which the authority could have concluded the applicant could reasonably have remained in their previous accommodation, it being undisputed that they were under a serious and credible life threat. At this stage, one must be careful to identify the time in respect of which Section 60, subsection 1, this is when homelessness was contained in the Housing Act 1985. Reasonableness is to be tested. There's a time when the person does or fails to do something in consequence of which he ceases to occupy the accommodation, and then there is the time when the person actually ceases to occupy the accommodation. The former may be contemporaneous with the latter, but need not be. If I'm right in the earlier part of this judgment, then the present case is one where, in the case of all the families, say household 3, the acts or omissions in consequence of which they ceased to occupy the accommodation preceded by quite a substantial period of time their actual leaving of that accommodation. It seems to me that the phrase, which it would have been reasonable for him to continue to occupy, refers to the earlier time, there being employed the additional phrase, had he failed to do something, I think it must mean had he not failed to do something, in consequence of which he ceased to occupy the accommodation.
Okay, I hit a difficulty at this point because so far we've been proceeding on the basis that the moment that matters is the moment of loss of accommodation.
Yes, and I will submit that Lady Justice Arden alters to that extent Mr. Justice Sheeman's analysis. But I think the starting point and the explanation of why you're leaving out of account started with Mr. Justice Sheeman saying that you don't look at it at the time when they left. You look at it at the time at which they did the act, which otherwise would have otherwise been reasonable had they not done the act. Now, at paragraph 25, Lady Justice Arden says this. So Mr. Justice Sheeman adopted a temporal approach and held that reasonable was to be determined by asking whether it would have been reasonable for the applicant to continue to occupy at a point in time before the deliberate act which led to the loss of the accommodation took place. It was common ground that this approach was to be adopted in this case, and in my judgment the approach of Mr. Justice Sheeman is in general correct, and in my respect, the words in general are informative. Mr. Pettit carries the temporal approach to its logical conclusion. He submits that Southwark should have made investigations into the position as it stood between Mr. Denton and Miss Salmon, his mother, before any bad behaviour started. It should then have made an assessment as to whether the situation was one which Mr. Denton had outgrown and whether he ought to be living independently of his mother. In my judgment, what the local authority has to do is to determine whether it's reasonable for the applicant to continue to occupy premises, ignoring the acts and omissions for which the applicant is himself or herself responsible. If that is done, in the present case, the misbehaviour has to be left out of the reckoning. I deal with the question whether Southwark discharged its obligation to make inquiries into the situation as it would have been if Mr. Denton's misbehaviour had not occurred under the next subheading. Now, my submission, Lady Justice Arden is there saying the logical conclusion of going back in time to the point before the behaviour took place is not right. What you do is you simply leave it out of account. And in my respectful submission, that accords with Lord Reed in Highley, saying in 2015, after both of these cases, that all the elements of section 1911 are to be considered as at the time of the loss of the accommodation, which is our case. But we say that in Denton, what Lady Justice Arden was mandating was an approach that says, at the relevant time when you consider the loss of the accommodation and the intentional homelessness, you should say, if we ignore or leave out of the reckoning the acts or omissions for which the applicant himself or herself is responsible, would it have been reasonable to continue to occupy the accommodation? And we respectfully submit that if one does that, what one is left with is an applicant who has, as I've already submitted, a secure tenancy and no ground for possession. It would plainly have been reasonable for her to continue to occupy.
I'm sure it's my fault, but I'm still finding this really difficult. It seems to me to be arbitrary just to say, oh well, let's leave the facts out of account. I can see why an approach to a proper solution. But section 191, at the time of going out of the accommodation, one of the criteria for the accommodation has to be that it's available for. There's various ways that people could try and get around that. One is the Denton/P argument, which is to say, well, of course it isn't available because he's made such a nuisance of himself. No one, his mum's not going to let himself in. And in the present case, that would cause difficulties because she's got a right until the moment that she's walked out. And the moment she does walk out, she doesn't have a right anymore to accommodate. So what I'm struggling to grapple with is whether there's based on the words of the statute, there's an interpretation which doesn't avoid observed results, and that would have to be by concentrating, or might have to be by concentrating on the state of the accommodation. So that if, for example, the locks have been changed, it's not available, or if someone else has gone in, it might not be available. But isn't the principled way to approach this by looking at the state of the accommodation, just simply asking the question, is the accommodation available? I'm probably using the wrong words, but you know what I'm asking.
My lord, can I answer that? First of all, we're going back to section 1911.
Yeah.
On page 46 of tab 2 of the authority.
Yeah.
Sorry, 46. And the use of the having argued that the tense used in respect of the question Lord Justice Phillips asked me about a person who does or fails to do was not material. But draw attention to the fact that in relation to continuation of occupation, the words used by the statute are, it would have been reasonable to continue to occupy.
That's inexplicable. You've got two criteria. One is that it is available for his occupation.
Yes.
But you know they've gone out of occupation.
But it's still available.
It's still available, but because you know they've gone out of occupation, you say it would have been reasonable for them to continue to occupy.
Yes, but would have been, in my submission, also must relate to the cessation of accommodation in consequence of deliberate behaviour, and gives the foundation for the point made by this court in Denton that it would have been reasonable to continue to occupy must mean it would have been reasonable if he hadn't done the deliberate act
But then you're bringing
that caused him to leave.
But then you're bringing back in the deliberate acts, which
Yes.
is exactly what Lady Justice Arden says you shouldn't be doing.
No, if he hadn't done the deliberate act.
It's a counterfactual. Is
Yes.
what you're saying. It's a counterfactual,
That's what
and you say the counterfactual must be that the reason he didn't, that the person didn't continue to occupy was because of the matter set out in the subsection.
Yeah. But the question for the court, or the authority initially, when looking at the question of reasonableness to continue to occupy is, would it have been reasonable for them to continue to occupy? And that must mean, in my submission, if he hadn't done something in consequence of which he ceased to occupy.
I think we're going in the same direction. Because what I'm seeing is whether to keep closer to the words of the statute, you simply say these requirements are requirements of the state of the property, not him.
that just for a moment to reflect on that question. I think in terms of that may be right. With great respect, obviously.
Well, it's what's bothering me, because this everybody knows that homelessness is a complete minefield,
Yes.
but that it should be possible for people to understand what's going on. And as I think I've made clear, my concern is that although I accept we're talking about counterfactuals, the statute gives two requirements for the property that has been left, the accommodation that's been left, and they're both expressed as being not to do with the function of the person who's gone out of occupation, but as the property. That's what I'm niggling away at, or the accommodation.
The way I would
What if though if it was suggested that it wasn't reasonable to continue because, for instance, fear of domestic violence?
Well, there's a specific provision for that.
There are questions that sometimes arise in relation to whether it was reasonable to continue to occupy in terms of somebody going before they needed to, or if the rent became so unaffordable that it wasn't reasonable to expect them to remain and rack up a large debt when the obvious result was going to be that they would at some point have to go. And it seems respectfully that what Parliament is getting at here is, if I can use a colloquialism which may or may not be helpful because I've only just thought of it, somebody who leaves by virtue of a deliberate act in circumstances where they shouldn't have.
What have you got employment at the other end of the country? You deliberately left, but it's not reasonable for you to continue to occupy.
Yeah.
And that's nothing to do with the property, that's to do with your employment status, or because of some personal connection, your some relative needs caring for something
Yes.
in a far distant place. You might leave your accommodation. It's nothing to do with accommodation, but it might be thought to be reasonable.
I would accept that, and this is why I am being slightly circumspect about the approach that my Lord Justice Smith is putting to me, because I'm not sure that one can always say that it relates to the state of the property. Reasonableness to continue to occupy, in my respect, submission, relates to the circumstances of occupation if you'd not done a deliberate act which caused you to leave. In the same way as perhaps this is also instructive, Section 175, which defines homelessness, which I took the court to initially, says a person is not to be treated as having accommodation. If it wouldn't be accommodation, it would be reasonable for them to continue to occupy. And that seems to me, and it's established that Parliament introduced that requirement to fit in with Section 191, so that a person who left and was not intentionally homeless would be deemed not to have had accommodation, so you'd be homeless, as opposed to being, in the case of Pulhofer, which was referred to by Lord Reid, but I didn't take the court to it, before Section 175, as it now is, was amended to include the requirement of Section 3. The court held, well, the accommodation was of such a bad standard that had they left, they would not have been intentionally homeless. But because Section 175 didn't include the same proviso that it would be reasonable to occupy, the only requirement for someone to be homeless was that they did not have anything that could fairly be described as accommodation, and that can't have been. Parliament plainly thought that was wrong and amended the legislation. So it's a long way round of saying that I think the concept of reasonableness to continue to occupy is in many ways at large. One has to look at all the circumstances and see whether it would have been reasonable for the person to remain. But you have to look at that in the context of someone who has left and who has left in consequence of a deliberate act. And then you say, well, had that not happened, would it have been reasonable for them to have continued to occupy? And that's what
does this get closer in deciding whether the two criteria at the accommodation are met? A person who has by their own deliberate act caused the loss of accommodation cannot rely upon that to overcome the requirements of the accommodation. I'm getting very close to going back to Lady Justice argument.
Yes.
That it's this concept of not being able to rely, or I'm still worried. I'm going to shut up in a minute, maybe, possibly. But I'm still worried by this sort of just a bland statement. You just leave everything out of account. There's got to be a reason.
The person can't rely on their own deliberate act which caused the loss of the accommodation, or the loss of the accommodation, as a reason why it wouldn't have been reasonable to continue to occupy.
So that's a reason why A, the accommodation is not available,
Yes.
and B,
Yes.
would or not.
Yes.
Okay, I think I can do this. I'm sorry it takes so long.
No, not at all, my lord. As my lord observed, these are provisions that have given rise to huge complexity. I suppose the straightforward answer would be, well, one simply applies what Lady Justice Arden said.
Yeah.
But I entirely understand why my lord wanted to reach further for a rationale for that. And I think the rationale must be that it can't have been Parliament's intention that a person would be able to say, well, because I acted in such a way that I was thrown out, it can't have been reasonable for me to have stayed there.
Yeah, thank you.
Well, it's noticeable that different wording is used, which is available would have been reasonable.
Yes.
Is that because availability is an objective question, which can be answered on the facts at the time, as you say, on the date of ceasing to occupy, whereas would have been reasonable, that does involve a counterfactual.
Yes, my lord. I think that must be right, respectfully. The question is, you cease to occupy accommodation which is available in the sense that it's somewhere you've left, not because you couldn't physically stay there, but because of an act that you meant that you were not allowed to. But the property itself is available, in the sense that at the time 87 Thompson Avenue left, it was still a house that was still available for someone to occupy, and
that's where the eligibility point comes in, because if you're not eligible, then it's not available for his occupation.
Yeah. But reasonableness is a concept that requires you necessarily to look at the counterfactual situation, because otherwise it makes no sense at all. And the worse the behaviour, the less reasonable it would be for you to continue to occupy.
Yeah, well, that's the sort of bull point that underlies the whole of your both sides submissions. the worse the behaviour, the less likely you are to be intentionally homeless.
Yeah.
Sounds a bit odd.
Well, that's certainly our position. So finally, I think I need to come to Chishimba and to some extent Glidden. And Chishimba is at tab 21. Page 307. We have in the judgment of Lord Justice Lewison the reasons given by the local authority in that case for terminating the accommodation. Page 310, paragraph 3 of his judgment, or just at the very top of that page. Right, actually, can I start? I do apologise. Page 309, paragraph 2. The UK Border Agency discovered the existence of the counterfeit passport which Chishimba had used to get the accommodation. She was prosecuted and sentenced to a suspended term of imprisonment. And they also informed the council. Armed with that information, the council decided that its housing duty had ended and served her with a notice to quit. The letter informing of that decision reads, in its material parts as follows: my understanding that you're a Namibian national who was granted limited leave to remain that expired on the 21st of January. You are therefore classed as an overstayer who is ineligible for housing assistance under the Housing Act 1996 Part 7. As a result of the above, this authority shall cease to be subject to its duty towards you, as defined under Section 1932. Further, this authority is of a view that it has discharged its duty to you in accordance with Section 1936A, which states that the duty will cease if the applicant ceases to be eligible for assistance. As a result, the accommodation will be terminated. So, it seems respectfully to the appellants in this case that regardless of any general principle that may or may not exist, Lord Justice Lewison was entirely right, respectfully, to say that in this case, the local authority terminated the accommodation not because she told lies to get it, but because she was an overstayer who was not eligible for assistance. That's the reason they gave her at the time they made that decision. It then followed that the court made an order requiring her to give up possession. Subsequently, paragraph 4, third line, secondly, on the 21st of October 2011, she had been granted leave to remain in the United Kingdom until 2014. The consequence of the grant of leave to remain was that she became eligible for welfare benefits and housing assistance, and she reapplied for homelessness assistance. And it was at that point that, in finding her intentionally homeless, the local authority said that she had lost the accommodation. This is paragraph 5 of the judgment. At the bottom of that page, I'm satisfied the accommodation would have remained available to you for an indefinite period had you not ceased to become eligible for assistance when your possession and use of a counterfeit passport was brought to the attention of the council's housing needs section. I'm satisfied with the act that has led to the loss of this accommodation was the fact that you had obtained and used the counterfeit passport to obtain housing, and that this, together with the subsequent discovery of your deception, has led directly to the loss of your accommodation and consequently your homelessness. The deliberate act was not necessarily done with the intention of causing homelessness, but in your case you argue you obtained a counterfeit passport in order to obtain housing, but this in fact has also led directly to the loss of your. So one has to distinguish, in my respectful submission, between the reasons given for terminating the tenancy at the time, which were you're not eligible for it, and the reasons subsequently given when she applied as homeless, once she was eligible, for why the authority said she was intentionally homeless. And what Lord Justice Lewison says at paragraph 9, paragraph 10, is what act or omission on the part of Mr. Shimber caused him to cease to occupy? The deliberate acts on the part of Mr. Shimber were her acquisition of the counterfeit passport and her use of it to deceive the council into accepting her claim to be homeless. But she argues the consequence of those deliberate acts was the acquisition of her accommodation, not her subsequent loss of it. What caused her to lose the accommodation was the discovery by UKBA and then the council of the initial deception, and the council's own decision to terminate her occupation. Underlying the council's decision and hence the loss of 34B was the fact that Mr. Shimber was not eligible for assistance in the first place. Well, that's what the council told her. So it's hardly surprising, respectfully, that that's the conclusion Lord Justice Lewison reached. If one wishes to travel back in time from the possession order via the discovery of the falsity, the real and effective cause of the loss of accommodation was her ineligibility for the initial grant. Now, one must bear in mind in my submission that this decision was prior to Hiley. And what we've said in our skeleton argument is that we don't quibble with the outcome in Shimber. In my respectful submission, and again with great respect for Lord Justice Lewison, in my respectful submission, that is not necessarily the question that one should now ask in the light of Hiley. It's not whether the real and effective cause was the ineligibility for the initial grant. It's whether the real and effective cause was, at the time of cessation, the fact that she was still ineligible for the grant. And his lordship continues that at 15, that because she never had the lawful right to occupy the flat, he agreed with counsel for Mr. Shimber that the case law, such as Watchman, don't support the council's decision. I accept the argument for Mr. Shimber, the immediate approximate cause of the loss. This paragraph 15.
Thank you.
We say this is the point. The immediate approximate cause of loss was the council discovery of her fraud. If one travels back in time from that immediate cause, then one arrives at the conclusion the effective cause of her no longer being able to occupy was that she was not entitled to it in the first place. Well, that was the reason that applied when she lost it, not just when she got it. She was never entitled to it, never meaning at any time during the length of her occupation, not just never at the beginning. Similarly, at paragraph 16, a similar analysis underlies Mr. Shimber's argument that it was not reasonable for her to continue to occupy. Because of her initial deception, she should not have been granted the tenancy in the first place. When the council discovered the deception, they terminated the tenancy. How can it be plausibly said that it would have been reasonable for her to continue to occupy a flat to which she never had any lawful right? The reviewing officer did not address this question at all.
I can see that in relation to 16 and reasonableness, that plainly eligibility, it creates a clear distinction between that case and this case, and availability is not, I suppose. In relation to the first question addressed in 10, to a large extent, the analysis can be applied here to a certain point anyway. What caused her to lose the accommodation was the discovery, and then discovery of the deception, and then the council's decision to terminate. That's exactly parallel with this situation, isn't it?
It is. The only word I would quibble with is the word exactly, because the decision to terminate was not that of the council in this case, it was that of the court, on proof of a ground for possession based on false statement.
And that's because it's on non-secure tenancy, they can terminate it.
Yes. Yes. They can
And then they still have to get a possession order. But that's the
Well, it's one additional step because the council has to decide to apply them.
Yes, but that is certainly true in both cases. But because at the date of the discovery of the deception in Shishimba, she remained ineligible for assistance, ineligible for the accommodation she was living in, and that accommodation was not secure because it was homelessness accommodation provided within the exception to security of tenure in Schedule 1, Paragraph 4, which we saw earlier. So for those combined reasons, the authority owed her no duty to house her. She was prevented by law from being assisted by the council under the homelessness provisions. And the authority had the power simply to throw her out, albeit sensibly it obtained a court order to do so because she was in occupation. So, if one reads the decision letter at paragraph 3 of Shishimba, the council is saying, as a result of the discovery of your fraud, you are not eligible and we are terminating the duty that we have accepted to you. It was not saying, we never owed you a duty in the first. Arguably, it didn't ever owe a duty in the first place, but the reasons given for terminating the property were that she was, as a result of the fraud, not a person to whom accommodation could be given.
not as a result. It's not as a result of the fraud.
Not as a result of the fraud.
No.
Sorry, did I say as a result of
Well, I thought I heard you say so.
I meant as a result of her immigration status.
Yes.
She wasn't a person to whom the accommodation could be given. That applied at the start, but it also applied at the end.
It's a slightly more metaphysical question in some ways. Can a deception result which you use to obtain something in the first place be the cause of you losing it?
The answer is yes.
Well, there we are.
It can if the facts support that conclusion. And in this case, we say the facts do support that conclusion.
Because you say you've got it, but however you came to have it, you've got it.
You have to approach, we say, these provisions on the basis of the actual facts as assessed at the relevant time. And Lord Reid tells us that the relevant time is when you cease to occupy. At that time, as a matter of law, Miss Munemo had a secure tenancy which could only be terminated in one way. But we know that it was a secure tenancy, even though it was, to accept the argument, it was unlawfully obtained, because Kazim tells us that doesn't make the tenancy invalid. And we know that it can only be got rid of in one way, because this court in Ukam told us that there is no other way other than to use the methodology of Part 4, the ground for possession. And there is no other ground for possession that was applicable in this case. If one doesn't look at it at the date of the loss of the accommodation, then the entire exercise becomes potentially counterfactual and or an exercise in hypothetical. Mr. Walker, in the statement that he was allowed to put in before the county court, because this point was raised essentially for the first time in an amended ground of appeal and hadn't been raised in the same way at the time he'd done his review decision, says, we don't know what would have happened. There was an allegation of domestic violence that was subsequently made in relation to her other accommodation. One can speculate that she wouldn't have been entitled to the property. And it is absolutely fair to say, as I'm doubtless Mr. Nulby will say, that the council prosecuted the claim for possession on the ground that she wouldn't have been entitled to this property had she told the truth. But what Mr. Walker says as evidence in this case is it calls for speculation as to what would have happened had she told the truth. And as we know from Lord Reed in Hiley and the Dinn case, hypotheticals are not matters which the authority should be, or the court should be concerned with. As Lord Justice Lewison himself said in Shimba, you have to approach these matters in a practical and common sense way.
Except that we do have a counterfactual, which is the hypothetical on reasonableness.
We have that on reasonable things to occupy. What would have happened if she hadn't been?
That does involve, in a sense, speculation.
Well, it doesn't. It doesn't. In the sense of, if a person, take the fact of Denton, if the person had not committed the act which caused them to be thrown out, is there anything to suggest that they wouldn't have been able to stay? And we say that that is a limited counterfactual assumption, but there has to be something to suggest that it's not pure speculation, is what I'm trying to say. So to take the facts of this case, if there had not been a full statement, there would not have been a ground for possession. It is not, in my submission, fair to describe it as speculation that it would have been reasonable for her to stay, because there was nothing to suggest any inhibition on her staying at that point had she not been evicted because of Ground 5. So to that extent, there's a counterfactual assumption that falls to be made. But in assessing what would have happened on that assumption, we're still looking at the actual facts. What I'm suggesting is different in this case would be to go back in time and say, did the deliberate act, so this is the first part of section 101, did the deliberate act cause, or was it one of the effective causes of the cessation of occupation? Well, if she hadn't told a lie to get the accommodation, we postulate that she would never have got the accommodation, and therefore she would never have lost the accommodation, and therefore it can't have been reasonable for her to continue to occupy something that she wouldn't have lost. But we know that she did get the accommodation and she did lose the accommodation. So it's not merely a counterfactual assumption in that case, it would be an actual assessment of facts on a false basis. I think that's the distinction I'm trying to draw. So, in my respectful submission, while we don't seek to go behind or ask this court to in any way cast doubt on the outcome in Shishimba, we say that it shouldn't be extended to cover a situation which did not apply in that case for two reasons. One is that Lord Justice Lewison did not purport in his judgment to create a general principle about what must always be the case in situations of housing fraud, full statement. And secondly, which is related, that causation is always essentially a question, in essence, of fact, relating to the facts of the specific case. And in relation to a case such as this, where the facts are so different, and the legal overlay is so different, and the reasons for loss of accommodation are not the same as the reasons given in the Shishimba case, one shouldn't extend the principle, if it was a principle enunciated by Lord Justice Lewison, to cover every case of intentionality where false statements were made, however different that may be. My Lord, finally, on this point of distinguishing this case law, I need to just briefly go to a case that Lord Justice Lewison refers to at paragraph 19 of his judgment, where he refers to Mr. Justice Wolfe, as he then was, who had said in the Glidden case, where you have a situation where a person has only obtained accommodation on the findings of the council by deception, and the landlord, on discovering that deception, requires the person concerned to surrender their lease, the consequence must be that the person has no possible justification for refusing to do so. In my view, it's almost inevitable that if this is required by the landlord, it would be unreasonable for him to continue to occupy the accommodation against the wishes of the landlord. He would have no defence in law to a claim to possession by the landlord. That is true of Chishimba, and it's true in Glidden, but it is not true in our case. She did have a defence, namely, you haven't established a false statement, or if only, it would not be reasonable to order possession in all the circumstances of the case. But what is instructive, in my respectful submission, from Glidden is the actual situation in that case, because with great respect, I think it's very dangerous to take out of context what Mr. Justice Wolfe was saying. Glidden is at tab 8. And on page 139 of the bundle, there's a paragraph beginning at D. There were difficulties with regard to the payment of rent, and the rent went into arrear. Mr. King, who was the landlord, contended the applicants had obtained the tenancy by deception. They'd represented to him they were both employed. They could afford to pay the rent. They were not in receipt of supplementary benefit. And in addition, the name was Glidden, not Glidden. On account of the situation which had arisen, the applicants surrendered their tenancy and received instead a license. The license was for an extremely limited period, and in due course it was terminated. They didn't leave voluntarily, and an order was made. Possession was obtained. Now, on the next page, after they'd applied for homelessness accommodation, the council sent a letter, which is at the top of the page. 1, you gave false information. 3, that Mr. King was deceived by that false information. 4, that when he subsequently discovered this deception, you agreed to surrender security of your lease for a license. 5, and this is the key point, before surrendering the lease, you were advised by a member of the City Council Housing Department that you should not surrender the lease without taking legal advice. You did not take such legal advice until after you surrendered the lease. You were therefore made homeless as a direct result of your own actions, knowing full well what the consequences of those actions would be. In other words, you left, you surrendered your lease without doing what the council told you you should have done. And you became homeless as a result of that, knowing full well what the consequences of those actions would be. And the judge says when one looks at those reasons, one notices that the deception plays a prominent role in the matter. And that in addition to the deception, there's reference to surrendering without taking legal advice. With regard to the question of whether or not the council was entitled to come to those conclusions, the terms of section 17(1) and 2 must be borne in mind, and those are the same with provisions that now appear in section 1911 and 2. But he then says, subsection 4, which is also relevant, provides, regard may be had, and this is the power to take account of general circumstances prevailing in relation to the housing in the local area. And what the judge then says on page 141 first of all, at B to C, if the council had come to the conclusion that they lost the accommodation simply because they didn't pay the rent, that wouldn't necessarily have been a wrong decision. However, it's apparent that the decision didn't turn on non-payment of rent. And then at C, the crucial finding of the council is that Mr. King was deceived and that when he discovered the deception, the appellants agreed to surrender the security of their lease for a license. No doubt the council is right that on the reasoning of the council, the homelessness of the applicant was caused at least in part by the deception which they practiced on the King. But it doesn't follow that as they were rendered homeless by that conduct on their part, it would have been reasonable for them to continue to occupy. And he goes into section 17.1 before saying, where you have a situation where a person has only obtained accommodation on the finding of the council by deception, the landlord on discovering requires the person concerned to surrender. The consequence must be that the person has no possible justification for refusing to do so. And this is the passage relied on by Lord Justice Lewis. It says it would be unreasonable to continue. He would have no defence in law to possession, and it would be adding to the harm which has already been done to the landlord to require the landlord to bring proceedings in those circumstances, and notwithstanding section 17.4, which, as council points out, is there to protect the council. The needs of the council cannot in the ordinary way make it reasonable for the applicants to continue to occupy the accommodation. What I submit Mr. Justice Wolf was saying is, so far as the council was saying to the Gliddens, you shouldn't surrender your lease, you must stay and get legal advice, they weren't entitled to do that. Because it would be unreasonable for them to stay in circumstances where they had no defence to a claim for possession, and they would simply be putting the landlord to a position where it would exacerbate the harm already done, forcing him to take those actions. And we see that further on the next page. Page 142, letter B, where Mr. Justice Wolf says, on this aspect of the case, it's only necessary for me to add that I apprehend it will be rare for a council or other housing authority to have the same problem in the future. Whereas here the applicants are alleging they were not guilty of deception and the landlord is alleging that they were, normally the answer of the council...
is that whereas here? Or is it whereas here? Sorry to interrupt you.
I don't know. I think it should be. I think it probably is whereas here. The applicants are alleging they were not guilty of deception and the landlord is alleging that they were. Normally, the answer of the council will be what apparently was originally the answer of the housing department. Take legal advice and let the courts determine whether or not the landlord is entitled to possession. In any case where the council is not satisfied that there was deception, there would be a reasonable course. That would be a reasonable course for the council to adopt, because the courts are clearly better equipped to determine issues of that sort. And if, despite being provided with that advice, an applicant voluntarily vacates premises and the council comes to a conclusion that he's intentionally homeless, where it's not satisfied there has been deception, the outcome will be different from this application. It's slightly convoluted, but in my respectful submission, what the court is saying here is the council required you to stay, and in the face of their own finding that you'd deceived the landlord, and they shouldn't have done because you had no defence to a claim for possession. It was unreasonable to expect you to stay and fight it out. But if it wasn't unreasonable to expect you to stay and fight it out, then it would be perfectly legitimate for the council to advise you to do that. What Mr. Justice Wolf doesn't say is, and if then the court decided that you were guilty of deception and had to give up possession, the answer would be ... So in my respectful submission, what Mr. Justice Wolf is saying is not wholly irrelevant, but it comes about in a very different context. It comes about in the context of a case in which somebody says, well, I did what the landlord told me because I didn't have any alternative, and the local authority says, well, we told you not to do that, and because you did it, and you became homeless as a result, you made yourself intentionally homeless. And Mr. Justice Wolf was saying, well, it's not as simple as that, because you can't always expect somebody to stay and fight to the bitter end. If they've got no basis for staying, if they've got no reason, no defence to a claim, you can't force them to. It's not reasonable to expect them to continue to stay and fight it out in court. So, what we submit is that Glidden is not, well, for anything else, it's only a decision of the High Court, but it's not actually as supportive as it may seem on the issue of reasonable to continue to occupy, because it was addressing reasonableness in a different context.
But it's still, nevertheless, looking at the original cause and effect and then perception,
Yes.
and relying upon that as to whether or not it's reasonable to remain.
Well, relying on that as part of the answer as to whether or not it was. So, the court was saying there, if you've got no defence to a claim for possession, it's not reasonable to continue to occupy, so as to force the landlord to take you to court and prove it. And Mr. Justice Wolf, if he then was of the view that there plainly was no defence and it was inevitable that they would have to go as a result of the deception. But that does not mean, in my submission, that if somebody who has committed a deception and does have a defence chooses to go to court and fight about it, that they could not be expected to stay. And it doesn't mean that if, as a result of having lost on the basis that Miss Munemo lost in the present case, it would not be reasonable to continue to occupy in the light of the law as it has subsequently developed in Denton and Highley and all those cases. Not to be forgotten that Glidden in 1985, before even P had been decided by Mr. Justice Sheever, certainly before Lady Justice Arden and Lord Reed had come to the conclusions that they came to. This was a very comparatively early decision, but it doesn't force this court into the conclusion that Mr. Justice Wolf was saying it's never reasonable to continue to occupy if you have told lies to get a tenancy. That is a principle that Lord Justice Lewison is said to have enunciated in Shishimba. We say he didn't go that far. He relied on the statement from Mr. Justice Wolf in support of his conclusions in that case. We submit that Mr. Justice Wolf, although he made the comment, in the context of what your lordships are deciding, was actually making it in a significantly different context and addressing a subtly different aspect of the question of intentional homelessness, namely whether if you leave before you need to, which is the DIN point, if you leave before you need to, are you intentionally homeless, rather than if you leave because of deception, are you intentionally. That depended on whether the authority was entitled to say, you don't need to. That's why section 17(4), the prevailing housing conditions, was relevant. So in a case like Din, the House of Lords said you didn't have to leave when you did. and because you did leave when you did rather than waiting, you're intentionally homeless. It doesn't matter that you would eventually probably have become homeless anyway, because that's not what caused your homelessness. You have to look at the facts as they are. Highly, subtly modify that to the extent that Lord Reed analysed the provisions as meaning that if for the time the local authority look into your homelessness, an objective event has taken place which necessarily has amounted to another actus interveniens, an intervening and completely separate act that would have meant you were homeless anyway, then DIN is modified to that extent and the authority shouldn't find you. But just as a person with security of tenure can be asked by an authority in an appropriate case to remain in accommodation until the courts have reached their decision, so too in my submission, it cannot be presumed as the intention of Parliament that the only person who cannot be expected to remain in accommodation, in occupation of accommodation, is the person who has lied to get it. They cannot be intentionally homeless because of the lie they told, because of this question of causation. It cannot have been Parliament's intention that people who tell lies to get public housing are in a special category which renders them immune from finding of intentionality if they leave as a result of their lies giving rise to an order for possession. And if that's not a presumption of the intention of the legislature that the court is entitled to make, then we submit that the court should strain against the construction of the legislation or the causation exercise that falls to be made under the legislation that has that effect, and should not extend the reasoning in Chishimba so as to give that effect, because it results in an absurdity. Well, Lord, I'm aware of the time. That's all I have to say on ground one. I don't propose to say much about ground two, which is the reasons issue. We say that the judge below wrongly held that Mr. Walker had not adequately dealt with the questions arising from Chishimba. Because although Mr. Walker did do that in the witness statement that the judge gave him permission to rely on, the judge focused almost exclusively on the reasoning in the decision letter, which by definition didn't deal with that, because it hadn't been raised. But it seems to us that if we lose on ground one, because Mr. Walker got the law wrong, then the reasons challenge probably doesn't matter a great deal. His reasons would be wrong, not because he didn't mention it, but because he got the law wrong. If, on the other hand, he was right, that Chishimba wasn't relevant, then it would follow that his reasons didn't need to explain why Chishimba wasn't relevant, because he did explain the reasons for his decision, and nobody had raised Chishimba at that point. So what I would propose to do, with the court's permission, is we've set out our case on that in our skeleton argument, and we rely on that and on the authorities we've referred to. And perhaps if my learned friend makes any points in response in his submission that I need to reply to, I can deal with it in reply.
Yes, well, that seems very sensible.
My Lord, can I just have a moment? If there's anything further I can assist with, there's
No, thank you very much. Nabi, I think about 3 minutes. Do you want to start for 3 minutes, or do you want to start fresh?
Well, my lord, I prefer to have a clear start at 2, if that would suit the court.
Very well.
But I'm in your hands.
will rise sitting in it too.
All rise this evening.